It is 10:05 Pacific time, 1 p.m. Eastern time. Much later in Europe. I'm not actually sure what time change, but let's call it evening. And so, to people all over the world who are tuning in, welcome. Very excited to host our first business trip live. We have a great topic, a great panel today on the topic of patent law in psychedelic medicine. On this topic, I've been thinking about it a lot over the last week and thinking about patents and psychedelics and psychedelic medicine and the moral implications of it all. And what I've come to believe is that patents within this space are really actually a catalyst for innovation and a driver that really helps incentivize companies and founders and teams to basically reward themselves for building IP and building around IP to make available to ultimately expand access to psychedelic medicine. And so I'm very excited to introduce our panelists today. We have three panelists, Jayashree Mitra, Graham Pechenik, and Adriana Kurtzer. And the format of today's event is going to be Ask Me Anything. We have some preset questions that some of our attendees have sent us in advance. So we're going to start with those questions, and then we're going to ask the audience to ask their own questions, of which my request would be to raise your hand in the Zoom participant window. And then I will call on you once we get to the Ask Me Anything portion of this event. So before we get started, let's introduce the panelists, starting with Jayashree Mitra. Welcome.
Hi, everyone. Pleasure to be here. I am an attorney, patent litigator by trade. I'm located in New York City. I started life as a neuroscientist. I was happily giving drugs to rats and seeing what it did to their brains. And one day I had a car accident and I needed another job. So I became a medical writer for a while. And then I needed another job because I was bored. And so I became a lawyer. And since I love science, I became a patent litigator. And that's what I've been doing for over 10 years now. I became involved in, well, I would say I've always been involved in drugs that work on the brain in one form or the other. And cannabis and psychedelics have a special place in my heart because that was the focus of my research. And I'm particularly interested in psychedelics because this is really a very interesting area to work on. It ties in science, medicine, historical plant-based medicine, and the law in very interesting ways. And I really look forward to this discussion.
Excellent. Graham, would you like to introduce yourself?
Sure. Hi, everyone. And I'm excited to see some familiar names. And I'm pleased to be here and talk to everyone. So my name is Graham Pechenik. I am a patent lawyer. My first psychedelic experiences really kind of transformed the way I thought about just thinking itself. And at the time, didn't really receive much encouragement about how I could pursue psychedelics as a career, even though I was working also in a lab giving drugs to rats and in another lab giving drugs to fruit flies. The investigators for the labs didn't really see a role that I could have in psychedelics, so I found some people who were interested in the cognitive liberty aspect and decided to go to law school and try to pursue that. And the realities of law school loans and things made me turn to patent law at first. But after about a decade working at large law firms for mostly pharmaceutical companies and some tech companies doing patent work, was able to have the ability to go out on my own and kind of come back to where I started. My dream when I was a sophomore after my first psychedelic experiences was to be someone who could design new psychedelics. I spent like most of my evenings in my free time reading Arrowwood trip reports and kind of fantasizing about this. And it's amazing. And I feel incredibly lucky that now, despite this kind of long path, I'm back, not sort of doing it my own, but working with people who are doing those things that 20 years ago I thought were the most interesting things. So I'm happy to be able to talk about them from a, from a patent perspective and be able to work on them.
Awesome. Thank you, Graham. Adriana.
Hello, everyone. It is such a pleasure to be here in a co-host capacity with Greg and Matthias of Business Trip. I am one of the 3 founding partners of Plant Medicine Law Group, a law firm, a psychedelics and cannabis boutique law firm that launched on November 4th. My partners are Hadass Alterman and Serena Wu. We like to say that we do everything but patent law. So it was very exciting to put together a panel in which literally we can sit alongside people that I consider the superheroes of law, that do something that I will never be able to do, and to be able to learn. I started my career as a corporate lawyer, capital markets lawyer at Simpson Thacher in New York, focusing exclusively on Brazilian IPOs. I'm from São Paulo originally. And it's interesting that in that part of my career, a lot of it felt like translating standards, translating how business is done between one country and another, with the common goal for all. And there's a lot about that experience that I feel like applies to the psychedelic space now, and I look forward to talking more about that. I then did a detour into the art world and the contemporary culture world. And it's funny, while preparing for this conversation, it's interesting how every industry or every space has its mores and its habits and its ways of doing things that are not always captured by the law. And so that's where sometimes tension evolves. And it was the same in the art world, as I see now happening sometimes in the psychedelic space, where sometimes underground or sometimes legacy people have done things in a certain way. And then there's a discussion once things start changing about the applicability of the law, about the changes in the law, and about the changes in the culture of something. So you guys will see me mostly as a sidekick here today, because it really is a chance for the patent experts to share their knowledge with you. But if anybody here on this call has any other general law questions, we are happy to chat with you.
Awesome. Thank you, Adriana. And you've been a great partner putting this together, and I appreciate that. So let's get into it. So we're going to start with some initial questions around patent law that, again, were asked in advance. So the first question is, which inventions in psychedelic medicine are eligible for patent protection? So Graham, could you kick this off?
Yeah, I can start there. And there's a sort of a saying in the patent law that what's patentable is anything under the sun. So it sort of shows that there's not that much limitation from the outset in terms of what is patentable. Of course, there are a lot of tools that the patent office has to determine what in fact it is that's patentable, because what's protected is a patent applicant's inventive contribution. So the sort of technical details of a lot of these tools are probably more than we want to get into here. But I think the way that is best to look at them is the inventive contribution needs to be both novel over what came before, and also limited enough that it doesn't capture too much of later innovation. So of course, the sort of main way we think about patents is that you can't patent something that somebody else has already done. And you also can't patent something that already just exists. So like a natural product alone couldn't be patented because it already exists in the world. So sort of the first way to look at what can be patented is looking at what it is, in fact, that someone has contributed to sort of the technology field or the field of science. So what is it that's new over what came before? But also the way I think people look at it a little bit less, but it's just important at the patent office, is what's the scope of that inventive contribution over what may come later? So one of the sort of paradigm cases that patent lawyers think about is a case that dates back to Samuel Morse when he invented the telegraph. He tried to file a patent on the use of electromagnetic signals to send messages at a distance. And the patent office said, well, you know, it's true that you invented one way of doing that, but you couldn't patent every way of using electromagnetism to send signals because you haven't, in fact, invented every other possible way of doing that. So, you know, we can kind of look at that as a touchstone of sorts to think of the fact that what an inventor should be able to get a patent on both has to be new over what came before, but also can't be so broad as to cover kind of downstream innovations. So I guess the way of looking at like what inventions are eligible, it's really trying to narrow the, you know, the scope of what a particular contribution is. And I'd say that sort of the second way that I would look at this, and the way that excites me the most about psychedelics in particular, is that most of what we think of as a kind of primary inventions in a similar space, in the pharmaceutical space, are the chemical entities themselves that a pharmaceutical company seeks a patent on. So a particular pharmaceutical compound. And generally, that's the first thing that's patented. That's like the main primary patent. And all the other patents kind of work in you know, another dimension sort of around that. But in psychedelics, all of the compounds, for the most part, the classic compounds are already known. So those things exist in the prior art. So there's this whole space for companies to file patents on inventions around them and not be blocked by this kind of patent on the actual compound itself. So for instance, like with psilocybin, there's dozens of patents that have been filed on ways of using psilocybin, different technologies around the, you know, the use of the drug, the delivery of the drug, you know, synthesis of the drug. That wouldn't really be patents that we would see in the pharmaceutical space, because once the compound is patented, then, you know, that company would be most likely to be the one that would be trying to protect these other sort of secondary inventions. Now, of course, we also are seeing lots of new chemical entities receiving their own patents. So that's another area where we're seeing inventions in the psychedelic space. And that's something that's really more similar to the, you know, the pharmaceutical compounds in the more pharmaceutical space. But I guess in terms of what's eligible for patent protection, I mean, it's really everything. I mean, so that's, I think, what's so exciting here, and that's what's really, you know, excited me about looking at Oregon, is that the sort of the space for innovation in psychedelics is so much broader and so many more dimensions open to innovators than there are in sort of the pharmaceutical and biotech worlds as they kind of stand before. I mean, it's pretty revolutionary, I think, in terms of the new areas for patentable innovations.
Jayashree, would you like to follow on?
Yeah, just a couple of points to add to Graham's excellent overview. First thing, the fact that it's federally illegal really has nothing to do with patentability as far as the United States is concerned. It can be federally illegal, doesn't get in our way to filing a patent application. Now, this is very different from trademark applications, and it's really important to keep that in mind. The other thing that we recognized during our cannabis, when building the cannabis patent portfolios, is your international patent application strategy. Because once we file the US application, we also want to expand outwards. Within a year, we have to file our PCT, which is the application we file with the international not to go into the details, but that's how you preserve your international rights. And then you have to consider which countries you want to file patent applications in internationally. And there you have a limited time period, and not all countries will have this expansive view of protecting patent rights over substances that are illegal. So it becomes an interesting game, because typically when we file patent applications in the pharmaceutical industry and say we are going to drug development and we want to get into regulatory approval, the idea is to have as broad protection as possible across the world in different jurisdictions, because patents are jurisdictional, so that we can protect our IP across all the countries where we may want to see has to be reconsidered in light of the fact that what we are seeking approval for may simply be illegal in different jurisdictions, and many countries may simply not have this expansive approach towards granting patents. So that's just a little bit I wanted to add on to Graham's excellent overview.
Yeah, great. It kind of segues into our next question, which is what types of patents have the most enforceable and broadest IP? So, I mean, Jay, would you like to sort of follow on to the to that question?
Sure, that's a very tricky question. Its question is what patents do you want to enforce? Patent litigation is expensive. You're looking at millions of dollars in expenditures to enforce your patent. And at what point does the patent become so valuable? When does it gain that kind of a commercial value in the market? And what makes a patent, the drug may be amazing. You may be helping millions of people, but your patent may be terrible. Or, the drug may be killing people and the patent may be excellent. So how good a patent is, what its scope is, how enforceable it is, this depends on a number of factors. And it's not, there's not a checklist that lets us determine ahead of time. So I would say you to start at the very basics is that you hope that your patent prosecutor has done a very good job in drafting the application properly, not surrendered a number of, not surrendered too much of the subject matter, and the claims cover your competitor's product, and you get good rulings from the court. For example, if your competitor's product has a good non-infringement position, can design around your patent, doesn't matter how good your patent is, they can come into the market. So patent law is a tricky game. And what patents are going to be most valuable and most enforceable, it's hard to make that prediction. The best prediction the best input we can give early on is to have a large portfolio of patents protecting as many aspects as possible, basically create a patent ticket around the product, and that hopefully will serve to protect your core IP at the time your product is most commercially valuable.
Okay. Graham?
Yeah, I mean, I think I would echo what Jay said at the end there about looking at the patents, not just in terms of what single patent might be most enforceable, but really looking at the kind of ecosystem of patents that are built up around a particular product or invention. And I think judging that kind of patent ecosystem, both of a particular company, but also in view of the other companies who are in that space. So I think similar to how I mentioned, there aren't any real patentability options for known classic psychedelics, so we're going to have these ecosystems built by multiple companies. It's similar in that comparing different companies' kind of patent portfolios in this space, I think, is going to have a lot of kind of novel issues. But in terms of determining what's most enforceable, I mean, I think it's just hard to say. I think Jay, I was trying to hope that I could follow up on her with something that's expresses some other knowledge. But some of the things that she said is true. I mean, it's difficult to find a way of putting your finger on kind of the a checklist or like a particular kind of gold standard way of looking at it in the abstract. So
it sounds like one thing you both agree on is having many patents is one way to get the broadest protection.
Yeah, I mean, I think that's true in this, especially in the sense that like every patent claim sort of rises and falls on its own. So a single patent might have 20, 30 claims, sometimes more. So the best strategy really for getting strong IP is to ensure that there's a whole hierarchy of claims, some of which are broader and maybe more vulnerable to attack based on some prior art. Some of them are narrower and they'll be easier to design around, but won't have the same issues around prior art. And having a spectrum of different things in between. And like Jay said, it's hard to know exactly what's going to be like a commercial product at the point you file a patent. I mean, it takes often 4 years, 5 years before a patent is issued. It may take that long to determine whether a particular compound is going to survive, preclinical trials and clinical trials. And for a non-pharmaceutical product, it may take a while before it's determined whether the market is going to be, appreciative of that contribution. So, kind of designing a strategy for claims at the beginning to make sure that there's really a variety within a patent too of patent claims that can withstand different types of attack. So, a broad claim to a whole class of chemical compounds might be very strong. So if you can cover an entire sort of like class of tryptamines, for instance, in one claim, that's probably a strong claim in the sense that you might be able to enforce that against a lot of competitors who may be trying to make different sort of tryptamine compounds that fall within that genus. But one chemical compound in that genus that exists in the prior art could knock out that entire claim. So it might be strong for purposes of enforcing it, but it's going to be something weaker and more open to attack from the prior art. So you have to look at analyzing kind of a patent in the sense of viewing the whole variety of claims that it includes.
And to follow on to Graham, you can also consider the portfolio as a whole, is that how many different aspects, you're not just looking at the compound, you're looking at the synthetic process, you're looking at the method of treatment. Maybe there is some other aspect, a formulation, a delivery system. Each of these could be independent patents or interlinked patents. So when we talk about a patent thicket, that's what we are talking about, is this entire grouping of patents which are surrounding the compound, surrounding your core, I would say, business, and affording it protection in many different ways. And not all of them necessarily need to be patents that you assert. These could be patents that you also use to negotiate in the event your core business is at risk, right? So having a single patent and relying on it and saying this is my broadest IP or my most enforceable IP, it's risky in light of the realities of how IP law works. Whereas having a portfolio where you have multiple tools and techniques that can help you think about different ways to defend what you have, your business model, is just a more practical way of dealing with the way IP law works.
Mm-hmm. Got it. Okay, sounds good. Let's move on to the next question. Graham, I think it would be good for you to give a brief overview of what the patent process looks like from a timing standpoint, from a what needs to be filed, at what point does the patent become public? If you could give a high-level overview, that would be great.
Yeah, certainly. So the patent process really should start at as soon as there's a particular inventive contribution that's sufficiently kind of developed enough to feel like it will at some point be commercializable. So it doesn't need to have been fully researched. In the case of like a physical product, it doesn't need to have been made. And it certainly doesn't need to have been put into any kind of preclinical trials or clinical trials. I mean, it's possible for somebody to compound a chemical structure that's never been synthesized. It's possible to patent a compound that's never been actually like tested in humans. And for like physical products, it's certainly possible for someone to get a patent on something that's never actually been created. So it's important, especially because, I mean, one of the questions you asked was how long before a patent is made public. Patents aren't publicized for 18 months. So the first 18 months after a patent has been filed, they're completely secret and nobody has access to even the fact that they've been filed. So, obviously companies will issue press releases and tell the world something about what it is that's included in a patent application, but the full sort of scope and depth of what's in there is generally kept pretty secret. So because of that, it's pretty important to file quickly because, especially in the psychedelic space, a lot of people are working on similar things at the same time. And, there's a big advantage because the patent goes to the person who filed it first. So there used to be in the patent law, and some still remember this, the rule was it was who was first to invent, and oftentimes, a later filed patent would get challenged by someone who, or rather an earlier filed patent would get challenged by somebody who filed later, and there'd be kind of a contest to see who actually invented it first, and people would go back and look at like lab notebooks and things. But now it's universal in basically every country that it's the one who wins the race to the patent office. But basically that one filing date you have is the one that ensures that you have priority over the invention. So it is very important to file as soon as possible. In terms of the process itself, generally what's done is to file a provisional application in the United States because that holds your priority date. That's your first to file date for basically every country in the world where people are interested in patenting, with the exception maybe being Taiwan. All members of the Patent Cooperation Treaty and the Paris Treaty follow this rule where if you file a provisional patent in the US, you can claim priority to it with a later application filed anywhere else. The kind of main question for a lot of filings is if somebody wants to get a patent as soon as possible or if they want to delay the sort of start of their patent term. So generally in pharmaceuticals, the value of a patent is towards the very end and sometimes right at the very end of its term because obviously a compound will need to go through trials, it will need to go through FDA approval. It may take a while before the market sort of picks it up, and it won't be until the end of that patent term where it really starts generating a lot of value in like a more kind of fast-moving technological space, like some form of software or an app or a piece of physical technology that might be sort of quick to be marketed and then replaced by something later. It can be important to get a patent both filed and granted as quickly as possible. But if someone files a provisional application, they have another year before they have to file the first application that starts the sort of clock of their patent term ticking. So by filing a provisional, you can wait a year and not lose any patent term. So it's generally good to file as soon as possible, both because you now get that filing date, and then second, because you still have a year before your patent term even starts. And during that year, you're able to add more by filing follow-on provisionals that include further data, further information, and each of your claims in your ultimate application can draw priority back to the first provisional that included that specific information. So you can file within a year 10 or 20 follow-on provisionals, updating with all the additional work you get before you have to file your either non-provisional, your first application in the US that would start your patent term, or a PCT application that allows you to then file in other countries. So the patent process kind of itself, like the prosecution of a patent, I think the best way of looking at it is it's a negotiation with the patent examiner about what the scope of the claims should be. So the way to do this best, I think, is to include as much information as possible in the patent and start with the broadest scope of claims you think you can get. Of course, knowing some of what we talked about before, you're going to want some narrow patent claims as well, just to have ones that can avoid certain invalidity attacks. But you also want to get broad claims. So you start with your sort of opening negotiation with the patent examiner is you go in with a set of broad claims. The patent examiner has the task of comparing what you've done both with the prior art and with what they believe the sort of follow-on future innovation scope might be. and they'll, give you a rejection and say your patent is too broad, you have to narrow it. And then the process of just prosecuting your patent is generally several years and several sort of negotiations with the patent examiner, either written or sometimes, by phone. You can have interviews with the patent examiner to kind of sequentially narrow your application with more information, narrowing your claims to a more specific invention until the patent examiner is convinced that it doesn't any longer read on something that came before, and it's not so broad that it's going to stifle follow-on innovation. So the patent process can, in theory, actually continue as long as you still have information in your application to continue that narrowing process. Of course, there's a point where there's such diminishing returns, any claim you could get would be too narrow to be really worthwhile enforcing. But in theory, the patent process really is just a negotiation that starts with your kind of broadest claim that you hope you can get and continues with the patent examiner until you either run out of value, I suppose, or get a patent. So that's kind of the process of prosecution itself.
Excellent. Thank you. That was very comprehensive. Jay, anything to add about the process?
I was hoping, Graham, you could talk about the expedited process that the USPTO does provide if you pay the nice chunk of money up front.
So I tend to work mostly with pharmaceutical kind of clients who want to have that extended and kind of delayed prosecution where, if you file your provisional, then you have a year, then you file then you file a PCT, and then now you'll have another 18 months before you even enter US prosecution. And often it's 3.5, 4 years before you even see an examiner. But there are ways of filing more quickly. So there's something called a fast track application, or where you can pay a few $1,000s and get your application. It's promised that you'll receive what's called a final sort of office action within 1 year. So that's oftentimes when you file, it'll be 18 months, maybe 2 years before you even get your first office action from a patent examiner. But this is supposed to accelerate the entire process within 1 year. And that's being done a lot in like software and more technology fields. And it's really just a matter of, paying money to sort of cut the line.
Right. And the reason I bring it up is because when companies are in fundraising processes and they need to show something to their investors, that's where this becomes very useful. In the traditional pharmaceutical industry, I agree with Graham, you want to drag out the process. But I wanted to bring this up because many of the investors and funders on this call may also want to consider, is it worth our while to go through this expedited process where we as attorneys do a lot of the work for the examiner up front and get the patent issued quickly within a year? And is it worth your while to pay that extra money so that you have something to show your investors? It's just a strategic business decision, really. But you're giving up something because we just do it very quickly, and it's a business decision.
Okay. So, and it's a few $1,000s or 10, 100?
I believe it's $4,000 is the application fee. Our fees become higher because we have to do more legwork on this process. It has to be a lot more due diligence involved. If I understand, I mean, I don't do patent prosecution myself, but from what I understand from the prosecutors, it just involves more work on our end upfront.
Got it. Cool.
So add $10,000 to the bill. I think it's a fair estimate.
Okay.
So I had a question for all of you about so we use the term prior art to talk about what the patent office and the patent examiner looks at and searches for in order to determine if something is novel. The psychedelic space and research went through many years of underground, not necessarily documented in traditional ways, research. So I guess my question is, how do you guys describe the psychedelic research universe? in terms of what was above ground during 40s and 50s and 60s, what went underground, because I've already seen some controversy that's happening nowadays because people are saying like, well, such and such company filed for something saying it was novel, but quote, we in the space know there were people working with it. So could you address this? It's not to say it's special to this industry, but it's important to the history of psychedelics that there was underground research done. Does it show up as prior art? Can you guys talk a little bit about that?
Yeah, and in fact, it is, I think, special to psychedelics, but it's also somewhat special to the other area where I work, which is cannabis. So I prosecute a lot of patents in the cannabis space, and a lot of them are around extraction processes and extraction equipment. And that's a space where people have been working for decades, but none of it has been published in technical journals, and none of it has been really made public except some, forums online where people share this information. But those aren't things that patent examiners typically have familiarity searching. So yeah, I mean, I'm definitely familiar with the fact that in cannabis, there are lots of patents that have issued without regard to prior art that's been known by others in the industry, but hasn't been as known to patent examiners. And obviously that's, something that can be corrected through litigation or through a challenge to a patent, but we know how hard that is and how expensive that is. So that's, something that's difficult to sort of rectify. And that's something that people take advantage of in cannabis. And we haven't really seen any litigations except just one that really kind of went nowhere, but there have been a lot of whispers about coming litigations, and some companies in cannabis that look like they're being set up to be sort of trolls, taking advantage of the fact that they know it's expensive to try to invalidate a patent, even though on its face, it pretty clearly covers things that people know have been being done for a long time. So, I mean, I think there are some options that people have if they're aware of areas where there may be sort of a lack of prior art. I mean, there are ways of introducing prior art to an ongoing patent prosecution. But of course, it means knowing that that prosecution is ongoing, and finding someone to speak to kind of understand how to get that in front of the examiner. But that is something that can be done. But once a patent issues, it becomes very difficult and very expensive to challenge it. I mean, every patent basically comes out of the patent office with a presumption of validity, that the examiner did their job, that the examiner reviewed everything that was necessary. And that presumption of validity, I'm sure, Jay, you can speak to this having done patent litigation. I mean, it's pretty difficult to challenge. You need to have very strong evidence in court to challenge the presumption that the government patent examiner did the job that they were supposed to do. So it is difficult to invalidate an often bad patent. So yeah, so I think one thing that people can think of in this space, if that's something they're concerned about, is finding a way to sort of keep track of what's been filed, finding a way of alerting others to that. So I don't, I'm now getting outside of sort of my typical wheelhouse, but I'm sure there are concerned citizen groups that can kind of come together and find ways to sort of ensure that, if not necessarily a patent won't be granted, but a patent won't be granted that's so broad, it would be, used in a kind of inappropriate, I guess, way, but in a way as like patent trolls have used patents in other spaces. So, we know from the technology space, and, I know from my litigation background, having defended against a lot of patent troll cases, that somebody with a patent that covers something somebody else is doing, very often that finds its way to a party, or to a party with a lawyer to use it to, sue that company to extract some sort of settlement value, because it costs hundreds of thousands to millions to defend against a patent case. So, yeah, I mean, there's the sad fact that I think we probably will see troll litigations in the psychedelic space, probably not before a few years, because we haven't seen it quite yet in cannabis, but it's getting there. But yeah, I mean, I think that is something that's really good that you've raised, and I think it's something that's good for people to keep their eyes on. And I mean, my hope, of course, is that the people who are getting patents now will be using them in kind of more of an ethical way. And it's to everybody's advantage, really. I'm going back to some of the things mentioned before, to get patents that have claims that are not so broad that they kind of read on things that people have already been done. But we obviously can ensure that everybody that has a patent is going to use it in an ethical way. So I think having an eye to that issue is important for people, and pointing it out more, so it's at the forefront of people's minds is a good thing to do. And I think once there are more examiners who become more familiar with this space, because examiners work within a particular art unit and they generally tend to see the same sorts of patents and applications come before them over and over, and they do become more familiar with it. And they can also kind of be educated. I mean, I think it only will take somebody submitting kind of a package of prior art in one application, saying, if they're done in the right way, where they can get one patent examiner to realize, oh, I've missed this whole scope of all these things that were posted in this, particular space online that I didn't even bother searching. I think the patent examiners generally want to do the job that they have before them. I mean, they have constraints. They're very busy. They don't have a lot of attention to put on a particular application. But I think they want to be able to grant patents that aren't covering things that they should not be. So yeah, so I think the process, if it works, and if we think about how to make it work, can avoid these sorts of problems.
I will add, from a litigator's perspective, I think this is going to be the most fun part of litigation, because examiners search in one way, litigators search in a different way. Well, I will not say different way, but we are more aggressive. And we look at what is prior art also through the prism of litigation. For example, prior art, the touchstone of prior art is public. It has to be public. If you say something is underground and something is secret, how did the public know about it? If there were two people who knew a specific way to cook something in their basement and kept everything in a locked drawer, that's not public.
Yeah.
And for you to now, go ahead, Graham.
The patent examiner is not going to go on blue light or some,
yeah.
I mean, they probably don't even go on Reddit. So unless it's published in an academic journal, then,
so you have to show it was actual. So there's a touchstone for how you define something as prior art. So somebody coming and saying, granddad used to cook, this particular pot cookie in 1962, and this is his private diary that he kept locked in his basement, and I found 10 years after his death. That's not prior art. I mean, okay, I'm reaching a legal conclusion here, but I'm just giving, a hypothetical situation. So what is prior art is a legal definition, and the touchstone of that is public availability. So these are lots of interesting questions. And let's talk about other issues. Foreign language journals, doctoral dissertations. We don't know what's hiding out there. And we are going to find a lot of this interesting stuff when litigators get involved, because we have professional searchers we use. And once we unleash them and look at these documents, who knows what we will find. And I think it'll become an interesting, it will become an interesting discussion, and we will, we will get the contours of what is patentable, what is not patentable, knock out a lot of the bad patents. Some of it will be expensive, some of it will perhaps not be that expensive. It's hard to tell. But this is an industry which has drawn a lot on past knowledge, and it also has come up with new things. So let's give credit for the inventors who have come up with new things. And let's also acknowledge that it's an inevitable part of an industry such as this, that we will get some bad actors, and we will have to clear out the bad actors in the due course of things. Yeah. So I'm not too worried.
Yeah, I think there's an interesting historic parallel that we can bring in here, which is what you're talking about, Jay, is what has been the standard of public knowledge. And I think what's interesting is, coming from the art world, that question was at the core of many of the Holocaust restitution art cases, where what used to be the standard of provenance research was deemed insufficient because it didn't unearth, or people were not required to dig deeper to evaluate the passage of good title from one owner to another. And people willingly, oftentimes turned a blind eye, even when within the industry we knew that ownership by X or sale on Y date obviously meant coercion. So I think that there's an interesting way in which, you know, not to say that this industry is special, but I think that there's a way in which our standards for what is prior knowledge or what is public knowledge might have to give a little bit and be a little flexible, given the value of the research that was done and only published in very small circles because it was illegal, because the substances were illegal and the research was illegal.
I agree with you, and we are flexible on that. I don't think there is that, you know, it has to be in a peer-reviewed journal, but there also has to be an understanding. It has to be public. Mm-hmm. Like, it has to be beyond grandpa keeping it locked in his drawer. If he shared it, say, with, you know, a group and 100 people knew about it, there is a fact-based argument to be made that this was sufficient, right? Like, he mailed it to all his buddies and everybody knew, you know, all his friends knew about it. Is that public? There's an argument to be made, certainly, you know. But, you know, what I'm saying, like you said, it's a fact-based argument. You have to look at what the facts are at issue, and you have to look at, you know, whether what the specific issues are related to that particular knowledge base. Mm-hmm. But at the same time, you cannot fully throw out all standards, because that also opens the situation to abuse. Anyone can come up with a document and say, this is prior art. We just kept it locked in a fridge or, you know, locked in a safe for 50 years. And you have to remember that, you know, that's a trade secret. That's great. That's how Coca-Cola keeps its, you know, rights preserved. But the whole point about having inventions and having novelties, that you have some kind of notice about what's out there, and that also gives people who are working in the field, you know, who have done a good faith search for what is out there before investing their resources in development. It's unfair to them. You know, mm-hmm. I spend millions of dollars developing something, and someone comes up with a piece of paper they kept locked in a, you know, in a safe for 50 years and says this is prior art. That's also a little unfair. So yeah. I think we have a lot of public policy considerations to balance over here, and a fact-specific inquiry to make. And I think it will be interesting to see how that argument plays out, balancing everybody's interests in this place.
Yeah. All right, so let's move on to the portion of the event where participants can ask questions. And the way that we're going to do this is you can click on raising your hand within Zoom, and I'll call on you. But I know I have one question which I got via the DM from Tim Schlitt. So Tim, if you would like to ask your question, feel free to turn your camera on if you want or not, and introduce yourself.
Yeah, no need to hide here. So hey guys, Tim Schlitt here, VC investor in the space via a fund called Palo Santo. But one thing, this whole topic of kind of anti-generic strategies has fascinated me. But one quick question I had for you guys was just if you could comment on the defensibility of fixed dose combination therapies. So, you know, there's been some talk of, you know, for example, LSD with MDMA or psilocybin with MDMA, or kind of combining two highly generic compounds and getting some more IP protection around that, since it would kind of fall into that fixed dose combination, you know, therapy bucket. I'm no IP lawyer, so you guys probably can comment more on whether, you know, how defensible that is. maybe Graham or Jay. I don't know who's best to start with. I guess Graham.
I'm happy to start. And yeah, and actually I just had a patent issue last week on a combination of a CBD and a atorvastatin, and I can tell you it's definitely possible to get a combination drug, but it really depends on what the prior art is. So for this, there was no prior art that existed, even though it was known that both compounds worked for a particular purpose, which was the purpose they were being put to in combination. I think with something like LSD and MDMA, I mean, we know, and there's certainly going to be prior art that's going to be before the examiner on the use of them together. So the just mere combination of them is, I think, very likely. And I'm you can see I'm very hesitant to say something's patentable or not patentable, because I know like people that are, if they're working on a particular issue, I don't want to kind of prejudge the outcome of something. But I can say it's definitely going to have some pretty significant prior art problems trying just purely to get a patent on that combination without more. But certainly there are lots of strategies one could use to try to get a patent on that combination. So, whether it's a particular regimen of how it's used, a particular formulation of how they're together, a particular, sort of means of administration. There are, lots of kind of supporting data that one could use to show that in a certain formulation they have some sort of unexpected results, whether the bioavailability of one versus the other, how the kind of characteristics of the two of them work in either a particular kind of dosage form or a particular administration form. So I think that's probably just scratching the surface too of the ways that one could try to seek patent claims around them. So I think, again, it just comes back to what does a prior art say? So, I don't think there's anything uniquely difficult about getting a claim on a combination drug, separate from anything else that, may have overlap with what came earlier. And there are, lots of examples, and having done pharmaceutical patents for a long time, there's lots of examples of combination drugs that received new patents, even though both of the ingredients, both of the compounds were previously patented and sometimes had a significant number of previous patents on them alone. So yeah, I mean, I think just standing separately, that's probably going to be a pretty difficult thing to get a claim on, but I think together with something else, that's, there's certainly possibilities there. So I don't, that's.
Yeah, no, so it sounds like kind of if there's some specificity around dosing or blood plasma levels or any number of other factors.
Yeah, and I mean, you can see the types of strategies that people use in this space are finding, new ways of describing the use of something or sort of narrowing it down. I mean, again, this goes back to now the kind of that negotiation you have with the patent examiner. So you go to the patent examiner and you say, I want to claim on LSD plus MDMA. And they come back and say, well, people have been taking these together. And you say, well, you have a handful of strategies you may go to next. So it's MDMA plus LSD in a certain, controlled release format, or maybe it's MDMA plus LSD, but only to a certain population of people that have a certain biomarker, or maybe it's LSD and MDMA, but you give them to somebody who wears a fitness tracker, who gets a signal or some biosensor that tells them when to take the next dose. So like, there's going to be some next step that you can include to try to, avoid the broader prior art of just the, a candy flip together.
Yeah. No, that's helpful. That's really helpful, guys. All right, I'm going to go back in my cave. Thanks so much.
Great question. Thanks.
Yeah, thank you.
Hadass, I know you had raised your hand earlier. Don't want to put you on the spot, but if you still have that question, feel free to jump in and ask. Otherwise, I have some more lined up, if not. Or anyone else. Yeah.
Adriana, actually, she touched on it already, but thank you.
Okay, great. Any other questions? Okay, well, let's, we have more. Adriana, you look like you may have another one. I have other ones.
I have a question. So many of us have maybe heard the term open science thrown around, and many of us have also heard the term unpatentable, or certain organizations that are trying to create or work towards a situation where their work or their findings are unpatentable. Can you guys talk a little bit about what those two things are, what they mean, and I know that they relate to different people's like political outlook onto this world, but could you just talk a little bit about how they're similar, how they're different?
I can take a shot at answering that question. Typically, when at least I think about unpatentable subject matter, that's really what we call Section 101 problem. Some things that occur things that occur naturally are unpatentable. For example, if you have a plant that occurs in nature and you go and try to patent it. Now, I'm not talking about a plant that is, you've created and that's patentable as a plant patent. I'm just talking about, you walk into a rose garden, you pick up a plant and say, I'm going to patent this plant. That's unpatentable. And that's unpatentable subject matter. Are you going to try and patent sunshine? That's unpatentable subject matter. But there's also a movement, and it's not specific to this industry, but it's out there in many other industries as well, where people are opposed to patents, and they just take data that could otherwise result in patents, and they put it in a public repository for others to use, sometimes license-free, sometimes in exchange for a donation. But the general concept is we don't want to have patents. We want to give this to the public, which is fine. It's an ideological position. And what happens is that when they put this data out in public, if someone else has been working in the same area and they come up with similar data, this is already out there as prior art. So it's unpatentable in the sense you can't file a patent because it's public information already. So that's really the fundamental concept, is that whatever you're generating that's new, that's novel, that's potentially patentable, you're giving it for free to the public. Now, scientists are doing this all the time. They're coming up with great research and then they're publishing it in journals. Not all great research that's potentially patentable gets filed as a patent. People are giving things away all the time. And I think it's great if that's how you want to deal with the outcome of your research, by all means. So that's basically the idea, and it's been around, and not just in this industry, but in other industries as well. And if Graham wants to add to that.
Yeah, I think maybe I might have a couple things to add. One, I probably would start by just echoing what Greg said at the very outset of this, which was that the patent right itself is sort of given as an exchange to the inventor or the innovator for having come up with a particular invention and then sort of disclose that invention to the public. So it's seen as this exchange that encourages more innovation. In fact, the patent right is the only right itself, actually the only time the word right is used in the entirety of the Constitution. It's kind of baked into our political system that we have this patent right. And it's, I think, an important one. And I think when we sort of look at open science or open patenting, one of the, I don't want to call it a mistake, but one of the things that sometimes is sort of seen as being a problem, I think is not a problem. So the way I would explain it is like, a lot of people see patents as being either you don't have a patent or you have a patent and you use your patent purely for creating a monopoly, profit maximization, blocking all competitors. But the patent right is not necessarily something that has to be used that way. That's just a business decision that the owner of the patent makes. The patent provides control for what's covered in the claims, but that control can be used in a number of different ways. So it doesn't need to be used solely to ensure that nobody else has the ability to make or use what's covered by the patent. It doesn't have to be used in a way to ensure that everybody who has access to something that's patented has to pay as much as the market will possibly bear. And in fact, there are lots of scenarios and there are lots of other examples where patents are used in a way to maintain control over something, but not necessarily in a one that's purely driven by sort of capitalist or profit-dominated tendencies. So, it's possible to have like a kind of a patent cooperative or patent pool where patents are used to, for instance, ensure that other members within the cooperative actually abide by the ethical principles that they've agreed to. And patents in that scenario are actually, I think, optimal compared to other forms like contract, because if you use contracts to try to create a structure where people follow particular kind of ethical guidelines around using a particular technology, but if the technology is not covered by a patent, somebody who's not a member of that kind of cooperative or that contract structure can just go ahead and use it however else they want, because there's no other protection that follows the technology itself. But if you've patented that technology, the protection that goes with the technology follows it everywhere it goes. So you can ensure that anybody who uses this technology now has to abide by whatever principles they are. So they don't need to be profit maximizing principles. They can be anything. You can ensure, for instance, that if somebody is going to make and sell whatever your invention is, they have to do it in a way that abides by whatever kind of guidelines you put on it. So I'm speaking in a kind of abstract sense, and we can sort of fill out what those might be, but the goal of the patent doesn't necessarily have to be purely to obtain like a market dominating monopoly position that you use solely for your profit extracting benefit. It can be used in any number of ways, and the patent right itself is really just a legal right on a particular whatever it is that's covered by the claims of that patent. So there's ways it can be used that are sort of non-adversarial and
yeah. Nice. Quick follow-up, and then Matt, we're going to get to your question next. Have you seen any of that language or the clauses, the caveats, so to speak, thus far within psychedelic medicine, Graham or Jay, or is that just something that can happen?
Actually, so one of the clients I'm working with that I'm really excited to be is someone it's kind of adjacent to the psychedelic space. It involves psychedelic technology that's like in the VR space, and the patent was actually written with the goal of ensuring that this technology would only be used and shared between companies who didn't use it to obtain user data that then would be sold or used in a kind of a way that would violate particular kind of privacy rights. Or so we actually spent a lot of time thinking about how we would go ahead and ensure that companies sort of followed these ethical guidelines. And we thought about ways of using contract, but then we thought, what if we just put this technology out there? Anybody can use it. A company like Facebook could use it. And I have nothing against Facebook, but if they had this technology, they could use it in a way to gather user data that would be, at least in violation with this client's ethical principles. So we thought, well, if we patent this, we can ensure that when we license this technology to other companies, we make sure that the license agreement says that they have to tell the user every time that they're, could potentially be giving away their data, not give away the data unless certain guidelines are followed. And so this technology could only be used basically out in the world if it was used in very specific ways with very specific sort of ethical principles in mind. So just open sourcing that technology would not have accomplished that, because then anybody would have been free to use it, and any company could have used it for their own purposes, which this, the client thought could potentially be sort of have dystopian overtones of, being able to like, read people's kind of emotions and sense people's, state of mind through their, through the information that was gathered, and then be able to kind of use that in negative ways that were, the patent was sort of put in place to try to avoid that from being something that could happen. So that's
cool.
I guess it's somewhat like what we're talking about.
Yeah, really. That's a great example. Matt, I know I said I'd call you one moment because Jesse has a question on this topic. Want to make sure we get that in, and then we move to Matt. So Jesse, jump in.
Thank you so much, Greg. And thanks to the attorneys here speaking. It's very informative. So on this subject of caveats and conditions related to a particular patent, I want to bring up this idea of reciprocity to indigenous peoples that is often brought up in this sector. So in 1989, somebody patented the basic pharmaceutical innovation of ayahuasca with the USPTO. The patent was ultimately expired in I believe 2003. But what you had there was a situation where somebody took an innovation from an indigenous group, patented it in the US, and didn't really have any reciprocity conditions built in. So my question to you is it possible looking forward for that same kind of process to occur, but including what is necessary to create this sense of reciprocity, and not only a sense of reciprocity, but actually a flow of capital to indigenous communities from whence these innovations are coming, whether those innovations apply to a particular recipe, such as the mixing of multiple plants together, or a particular indication, such as the use of a plant for the treatment of a particular thing. And then very specifically, I ask it in the context of a company that has made a splash lately called Journey Collab, which is focused initially on mescaline medicines. And they've made a pledge to donate or to grant 1/3 of their total shareholdings, their total equity, to indigenous communities. And so the question is, could they, for example, with their mescaline medicine analog or formulation that they're developing, include in that patent these caveats and conditions that lead to this flow of capital to indigenous communities and more of a sense of reciprocity? Thank you.
Yeah, that's a super question, and Jay, I'll let you answer if you had anything. I know I've dominated the time from the last one, but it kind of follows on what I was
go ahead.
saying,
Go ahead.
So maybe I'll start. Yeah, no, I mean, I think that is a really terrific example of a way that a patent license could be structured. So I think that's a really a great way of thinking about a possibility for using a patent license to perform something different than just the typical kind of profit maximizing function that oftentimes a patent has. And I won't comment on Journey themselves, although I mean I've heard that they're doing that, and I think that's a great idea. But I don't know if I have more to add than that. I mean, also, I might just mention to the ayahuasca patent. I mean, so that was a plant patent that's a little bit different than a regular patent. So there's kind of a separate issue there, which I know is not really part of your question, but I kind of have a tick where I like to correct this when it comes up, because that, I think, was a real kind of political and cultural, kind of an issue that was, from a political and cultural sense, definitely a really big concern. And I know it caused a lot of diplomatic tension between the US and countries, but the patent itself covered a single plant and that plant's cuttings and really nothing beyond that. So it's, I think, not very well understood outside of the handful of patent lawyers who maybe have read it. And it's not really understood very much, I think, amongst people, that there are even differences between what's known as a utility patent, which is what most patents are. And so other plant patents, like say Monsanto has, cover not just a single plant, but they would cover every single plant that has their particular genetics in it. Like this ayahuasca plant, despite the like fact that it was pretty shocking from a cultural and social perspective, was actually a very narrow plant patent that really only covered one single specific plant, and that plant's cuttings and clones. So I just felt the need to kind of correct that out there. Not necessarily correcting you, but I think correcting the perception that a lot of people have. Because I think that those issues around the patenting of a kind of indigenous medicine should be corrected generally by the patent system. I mean, we shouldn't see patents that are on things that are being done. So we shouldn't see people patenting, say, ayahuasca, or patenting, the use of, these medicines, except for really true innovations on them. But I think that even being the case, there are these other ways that we can find ways to encourage this sacred reciprocity and to give back to communities, because even though somebody's, say, making an innovation on psilocybin mushrooms, they weren't the first to use psilocybin mushrooms, and there's a long history of their use by communities who aren't benefiting by their patent on their latest delivery system for psilocybin mushroom compounds. So, I mean, I think as a psychedelic space as a whole, if we can, think about ways of encouraging people in this space to, think about how to give back to those communities in, through means that use, say, the patent system, which tends to otherwise, kind of get a bad name for being just a way of kind of monopolizing things. I think that benefits really everybody and benefits the space. And that's actually, what I'm kind of most excited about, actually, despite the fact that I'm a patent lawyer and thinking most often in terms of what the innovations themselves are that go into the patent, the technological innovations. I think the business innovations that use patents is the most exciting area of patents in psychedelics from sort of a more philosophical or like intellectual level, because the patenting of a technology is like the patenting of any other technology. It just happens to be psychedelic technology. But the way the patents are used, I think, because the psychedelic space and the sort of understanding of what business will look like and what business models and what, kind of rebuilding the whole, whether it's capitalist structure or the whole business structure within the psychedelics field, I think patents can play a big role in that sort of change as well, especially in thinking about how to use patents in a way that benefits the entirety of the sort of psychedelics ecosystem.
So to what extent can investors in a particular company require them to implement those kind of conditions through, for example, term sheets?
I mean, now you're getting way over my head. I don't really have an answer to, but I'm sure, the creative people who are thinking more on like, from the side of the investors. I mean, I would certainly be happy to kind of think that through more offline. I don't have a really a potted response to it.
I can jump in.
Love to be able to think more about it. But yeah, Adriana, if you can.
Yeah, I can jump in. So it's interesting, this question about reciprocity, and it exists in a bigger universe where many times companies try to do good, or companies try to say they're doing good because it's the right PR angle. And so I think that it's not just requiring that a company say they're going to do something. If that's truly important to you to the level that it would be in a term sheet, it's really thinking through the process of that giving, the due diligence that's going to go into building that process, and the allocation of resources to making sure that the giving is actually done. So a lot of times, in a prospectus, it's like the good stuff that a company done is left to like the last few pages, and it's a few kind of generic statements that are made. And it's important to kind of really dive into the promises and really kind of see if there's a process behind the promises, see if resources have been allocated, and see if people have not just found someone that they can give money to, but made sure that they've due diligenced the destination to make sure it's the right recipient. So if it's something to the level that should go on a term sheet, in your opinion, then it's something that deserves attention and due diligence and effort in design as well.
Mm-hmm. All right, that was very interesting. Matt, we're gonna go to you. Hopefully you haven't forgotten your question by now.
Thank you. Yeah, so hey everyone, I'm Matt Baggett, and I'm a neuroscientist and psychedelic researcher. I'm co-founder of a company, Tactogen, and I'm loving this discussion of using patents for good and just generally trying to sort of ensure that this whole ecosystem develops in a healthy way with reciprocity. And it reminds me of Creative Commons and the licenses that they created. And it would be great if someone would create a license like this that could just be dropped into a term sheet or into other deals that would have the stuff all written out in a way that's pre-vetted and is industry standard. But this sort of relates to my question, which is, I wonder if Graham and the other panelists could kind of take out their crystal ball and tell us what they see sort of happening over the next couple of years. You know, because at this point, there must have been at least 300 or 400 patents filed that have not been published yet. And so, you know, based on what normally happens, or maybe what happened in cannabis, can the panelists talk about what we can anticipate happening over the next 2, 3, 4, 5 years as these things get published? There's lots of conflicts, maybe slowly patents are awarded, and, you know, what's going to happen? This is going to be a real mess, right?
Yeah, I mean, this is what I spend a lot of my free time thinking about, and I can tell you, after all the hours and hours I spent thinking about it, I really don't have a good answer for that, besides that it really is going to be a mess, in a sense, to, like, you know, not put a positive spin on it. I mean, I think we're going to just start seeing patents get issued that cover something that the person who got the patent isn't the only one working on. Somebody else might be working on that same thing, and we're going to see businesses have to start to pivot to do things that they're now realize a competitor of theirs has been working on. I mean, even though it's there's quite a number of different companies, a lot of them are really working on the same types of things. I mean, I think, and I would hope that, like, part of what we're talking about here, patents being used for good, if there's like kind of an ethos in general within the system that everybody wants the same goals, all the companies kind of want to see mental health care being transformed and want these medicines to have the broadest reach to the most people, we won't see everybody pulling their knives out in a year once patents start issuing, but instead we'll see ways that people are working together to either cross-license patents or spin out new companies or pivot to new companies who can work on things without having the sort of looming threat of a patent enforcement action hanging over them. But it really is anybody's guess, and we don't know certainly that everybody in the space is going to be a good actor. So yeah, I mean, it's something that, I check my email first every day to see if there's another patent that issued, because I know that every single patent that does is like one more sort of part of the story that everybody is moving towards. So when all those patents that have been filed, especially in the last 6 months, start to publish, I think it's like the whole fabric of like the companies is gonna start shifting around, and we'll see a lot of activity, I think, between companies either cross-licensing or finding ways to perform other transactions where they can either sort of take on part of a company or part of a company's IP. But I guess it's anybody's guess how that's going to shake out. I mean, but I think that's the most interesting question, really. I mean, that's at least that's the lens as a patent lawyer that I see this all taking place. I mean, we can kind of see where we are now, and like just if we look at every company, just like going just straight forward, we can kind of predict what the future will look like. But like when you throw patents into it, it's like putting it all through like a kaleidoscope or something, where like the pathway of every company is now being bent in all these different directions. But like those parts of the kaleidoscope that are going to refract all these like pathways, we don't know what they are yet. So I mean, it is kind of a mess. I don't know. So I don't know if that answers your question more than just kind of underscoring the fact that it is a big question. But yeah, my crystal ball is, to the extent I have one, a pretty cloudy one that's going to take some time to settle. I mean, I think, you know, we know that companies are sort of like, they're all building a specific space that we can imagine they'll probably try to hold on to. So they'll sort of absorb more or sort of give off more from whatever their kind of core is. But I don't know. I think I don't have any wiser words than that to add.
Jay, how about you? Crystal ball.
Jay, I've stolen the floor from you so much. I don't know if you have any.
I'm more interested in labs. I was saying that I'm actually quite curious to see how the clinical trials develop, and also legalization. I think that's going to affect, because at the end of the day, what's the commercial value of your patents? So if we see more clinical trials, if we see results of phase 1 trials, things going into phase 2, if we see companies announcing successful outcomes or expansion of their clinical trials, if we see more greater movement towards legalization, I think the value of the IP is going to go through the roof or go boom. You know, either way, the next year or so is going to tell us a lot about where this industry is going. And also the interesting thing about psychedelics, it's not a single molecule. You know, one psilocybin could be huge, DMT not so much. We don't know, but which direction a particular molecule is going to move towards. So we're going to be looking at a combination of factors to see how the IP will be affected. And that, I think, is going to be the most interesting thing.
Yeah, and I agree with that. And having heard you say that, Jay, I'm abashed that I didn't kind of point that out more myself. I mean, out of the 300 patents or whatever have been filed, Matt, I mean, I think what is kind of important is how they'll end up being practical in what the future is. So if Oregon is the only state that allows a like legally regulated but not FDA approved type of clinical therapy to take place, a lot of the patents people have filed are not going to have much value. But if we see the Oregon model across the whole country in 5 years or whenever it is that like people's patents start being issued, there's going to be a lot more value in that. I mean, and I think the same is true with like individual compounds. I mean, if the FDA, it looks like they're on track now to approve psilocybin and MDMA, if they kind of show that they have a desire to approve other compounds, and we see a lot more kind of psychedelic compounds going through FDA approval and coming out as medicines, I mean, then we're going to see the value in that. But if the FDA looks like they're going to kind of stop there, and whoever's coming up behind psilocybin and MDMA with their novel chemical compounds face more scrutiny at the FDA, then there's 50 or 100 of those patents you've mentioned are not going to have the value that they would have if those compounds see a more streamlined process actually making it into humans, which is when the patent is going to have growth. So yeah, so Jay, I mean, I think that's really also the big issue, is really just what is the market going to look like, and like which of these patents are going to be important in that market. Those will be the ones that people are going to care about.
Yeah. And I believe it's psilocybin alpha that has a database of patents. I hope I'm not misspeaking on their behalf, but I think
No, and I'm helping psilocybin alpha, and I think Josh is on the chat,
Yeah.
so he can chime in too. No, we actually just before this call put out one on MDMA patents. Now we have one on psilocybin patents, one on MDMA patents, and we have a track or two that we'll do more of on press releases, because like as we've mentioned several times, patents aren't made public for 18 months. So that 18-month period is one where we just have to sit and wait. But we've tried to make that waiting a little bit more interesting by keeping a list of every time someone's issued, whether it's in a press release or made another announcement of patent being filed, keep those all together so you can kind of scroll through them and see how things are developing.
Yep, cool.
Yeah, and Josh just put a link in the chat, so
Awesome.
people can check that out.
Cool, thanks, Josh. All right, well, it is 11:30 Pacific time, which means we're at the end of our panel. I feel like we could probably go on for 8 hours, but just the way people got things to do. So I appreciate the lawyers on the panel. We got an hour and a half of non-billable time, so that's great. If anyone wants to be in touch with any of the speakers here, or really anyone else, hit me up. Happy to make a connection. And let's do this again soon. This was fun, and this is the first of hopefully many. So thank you for participating, and we'll speak soon.
This was great, everyone. Ciao.
Yeah, thank you all.